And then why have you not turned over the documents that was ordered?
I was in the process of getting the documents. I got some of the documents. This was sometime back in December, where I believe we had another show cause. In the process of getting that, my father fell ill and unfortunately passed away.
A debt so old it started in 2011. A debtor who missed not one, but multiple court dates. Documents ordered by the judge that never showed up. And today, DeAndre Carter walks in thinking he can explain his way out. Case Credit Union has been patient. The judge has been patient. But patience has a price, and that bill is now to UE. Watch how this man tries to excuse years of non-compliance in one morning.
Mr. Chernick, did you and Mr. Carter resolve your matter today?
No, we did not, Your Honor.
This is Case Credit Union versus DeAndre Carter, 11-04297 GC. Counsel appearance.
Good morning, Your Honor. Scott Chernich on behalf of Case Credit Union.
And Mr. Carter, state your name for the record.
Good morning, Your Honor. My name is DeAndre Carter.
Okay, this was a motion to show cause. Mr. Carter, you were before the court back on June 24th, 2025 for a discovery debtor's exam. You were ordered to turn over some documents that was requested by July 15th. Counsel, did your client ever get those documents?
We did not, Your Honor. And just to supplement the record, on July 15th, there was a motion.
I wasn't done. I didn't need that.
Sorry.
I just had one simple question. On July 15th, you failed to appear, which is why this is set for show cause. Mr. Carter, where were you on July 15th?
July 15th of 2025. I can't remember exactly where, but I think I had mistakenly put the wrong date on my calendar, if I recall.
Okay. If you mistakenly put the wrong day on your calendar, what day did you show up for your discovery exam?
I would have to check. Let's see. I don't have that offhand immediately, but I would have to look.
Yeah, so we don't have any record that you ever showed. And then why have you not turned over the documents that was ordered?
I was in the process of getting the documents. I got some of the documents. This was sometime back in December, where I believe we had another show cause. In the process of getting that, my father fell ill and unfortunately passed away. He fell ill in December, passed away in January, and I requested additional time, but did not get all of the documents to the representative. At that time, it wasn't Mr. Chernich, it was another representative of Case Credit Union. And I kind of in the whirlwind of things did not get all those documents over to Case Credit Union as requested.
These documents were supposed to be turned over by July, so this would have been before your father fell ill.
Yes, that was, that was, I was referencing both time frames.
Okay, Mr. Chernick, did you want to make a record?
I just wanted to supplement it, Your Honor. The court was absolutely correct here. Back in May, there was a subpoena. The defendant didn't show. In July, there was a motion to show cause and the defendant did not show. And then in December of 2025, there was another show cause. The defendant did appear in the court and instructed the defendant to produce documents by December 26th. Those documents have not been produced. And I'm just at a loss here, Judge. Mr. Carter's had ample time to produce the documents we've asked for. And the case has been pretty patient in waiting for those.
What was the December court date?
That was a show cause hearing.
What date was that?
December 11th, I show in my documents.
Was I here? I don't know if I was here. December 11th. Some of these dates, I don't know that I was here on all of these dates. I don't see any record or notes in my file from December. I do see February, there was another motion to show cause. I mean, I can understand family issues come about. I've had my own family issues and lost my mom during this time frame too, Mr. Carter. But that doesn't absolve me from my responsibilities. And you have a financial responsibility. This case number is 2011-04297. So this is a very old case. There's no reason why we should be dealing with this to get this matter resolved. I think that you are capable, more than capable enough to get this matter resolved. And whatever the reason why we're going through this is because they're trying to figure out how can they get their money or what to get the judgment satisfied. And you're ordered to comply. It's not an option. But you were supposed to comply in July. When are you going to turn over these documents?
I can get the documents. Let's see. What today is the 27th. It should take me a week or less. Well, I'd say 1 week.
Okay, and what specifically, Mr. Chornick, are the documents that you're still waiting for?
Well, I don't, thanks, Judge. I don't have any in our subpoena, have numerous document requests attached to it.
Mr. Chornick is going to receive these documents from you, Mr. Carter, within the next 7 days?
Yes. Also, I have a question when permissible.
Yes.
If I wanted to seek legal counsel to assist in this process, is that something that I should do prior to submission of the documents or after?
You can seek legal counsel all you want. That's up to you. This matter is not being litigated anymore. It's already resolved. There's a judgment that you're ordered and you must pay. And so they're trying to figure out how they can get recovery on the judgment that's already entered against you. And so you could just pay the judgment and then we probably wouldn't be here. But because they're not getting either any payment or a satisfactory payment, they now need to go fishing and figure out what's going on in his finances. So you can seek all the counsel you want. You got bills, you got to pay them.
Understood.
And that's what an attorney will likely tell you. So nonetheless, and they have every right to ask about your financial stuff before they start seizing things from you. So I'm ordering that you turn over the documents within 7 days. And I'm resetting this show cause. Mr. Carter, please don't put the court in a position where we have to now issue sanctions for your failure to comply with the subpoena.
Yes, Your Honor.
May 8th at 2.
May 8th at what time?
2 p.m.
At 2 p.m. is the reset date. Any additional matters for the record?
No, Your Honor. Thank you very much.
Okay. Anything from you, Mr. Carter?
No, not at this time, Your Honor. Thank you.
Thank you. You're all set. Mr. Carter, you're free to go.
Thank you, Your Honor.
This is Spring Oaks Capital versus Jamie Cook, 25-04017. Appearance, please.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Okay, and Jamie Cook, state your name, please.
Good morning, Your Honor. Jamie Cook, defendant.
Okay, today was the date that was set for a motion for summary disposition. And you all have not resolved this, correct?
Correct.
Okay, counsel filed a motion for summary disposition. Ms. Cook, did you file a response? Because I don't see it.
I did not file a response. The response that I filed was back in December, but nothing else since then.
Well, that was not a response to the motion of summary disposition. That was a answer to the complaint, which you denied jurisdiction, you denied parties, you denied the amount of controversy, and you denied that there was a breach of contract, but you provided no further explanation. And so all the more reason why you should have been responding to their motion for summary disposition. Because you can't just put denied, denied, denied. If you're denying that the court lacks proper jurisdiction over this case, you have to assert why you believe that.
Okay.
If you're denying, it says parties denied. I don't know how you're denying the parties. But the plaintiff in their motion and during this case have provided the court at least evidence of a contractual relationship between you and the plaintiff, that there was at some point an agreement in that there were some payments that were being made by you, and then at some point those payments stopped, and then which is a default. And because of that, there was a breach of contract and that they're seeking recovery. You've not provided the court with any viable defenses to the debt. You understand that?
Yes, Your Honor.
Okay, so I don't know if your answer was just because you were told you had to file an answer, so you were trying to get something out there, or if you actually reasonably believe that you had a defense to the debt. If you don't have a defense to the debt, then you need to get into the private meeting room with Mr. Werber or work out some kind of arrangement so that a judgment can be entered or an agreement can be entered whereby you can repay the debts that you owe versus this, because the court's going to grant their summary judgment because I don't have anything to offered by you that would refute what they're saying. You understand that?
Yes, Your Honor.
Okay, so did you want an opportunity to talk to Mr. Werber at all, or?
Absolutely. I was prepared to respond orally to the response today. I didn't know I needed to submit that.
You can do so now. Yeah, you were
Okay.
supposed to do it in writing. You can do so now, though.
Yes, ma'am. I oppose the motion. Standing still has not been proven that the bill of sale is generic, and it did not identify my account specifically. And then also, there was hearsay with the witnesses with no personal knowledge that explained the issues for material fact to be presented in this case. So I requested that the motion be denied, Your Honor.
Okay, thank you. So after all I said, you still went forth with reading whatever you Googled off AI. I don't know why AI is messing people up and making them think that that is a reasonable defense, that there's no standing for the debt that you owe. The only argument you have is that wasn't my debt. I ain't never took out that credit card if it's true. If that's not true, then be honorable and make an agreement. Don't try to use Google to find some ridiculous argument that was placed on there to put in court to try to get around paying your debt. That's not a good practice. Motion for summary disposition is granted. Did you provide an order, Mr. Werber?
I am looking right now. I don't believe so, Your Honor. I will submit one right away.
Okay, and so Ms. Cook, the judgment will be entered based on their motion because you've not provided the court with any proper defense. And so the judgment will enter. You can speak to Mr. Werber or you can contact the plaintiff outside of this and try to get into an installment payment plan so that you won't later be garnished, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
No, thank you, Your Honor.
You're all set.
The judge gave him 7 more days again, after years, missed hearings, and excuse after excuse. Carter's choices built this moment, and the court's patience is not infinite. Sanctions are next, so here's the question. Does a judge showing this much restraint help someone get their life together, or just delay the inevitable? Do you think the judge was right, or did Carter waste yet another final chance? Comment below, hit like, and subscribe for more real courtroom breakdowns.